unique. You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell is that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I'm blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property. It'll be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Welcome to the show. Today, our topic is dealing with difficult real estate closings. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to give us a like and subscribe to our channels. You can find us on Facebook, you can find us on Twitter, and you can find us on YouTube. On YouTube, we are at INREM Podcast. That is at INREM Podcast. Make sure to go over there and subscribe. It helps us out a great deal, and we would really appreciate it. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So today, my legal update continues in my What If series. So the what if question for today is, what if a buyer who purchases a property subject to existing loans dies after the close of escrow, which means that the buyer actually owns it. There's title in the name of the buyer. And to answer that question, we have to know how the buyer took title. So for example, if the buyer took title in the name of an LLC, well, in that case, the LLC doesn't die. The LLC doesn't go away. The buyer is a member of the LLC. So let's say that the LLC's member dies. In that case, nothing changes. We identify an individual as being the buyer when in reality they took title. They were an investor. They took title in the LLC. Well, the LLC continues to own the property. The LLC will have to continue to make the payments. So whoever's responsible for the deceased member's estate will have to step in and make sure that the payments are being made on the existing loan, and the property is being kept up and everything's being done properly with respect to the property. But nothing changes. The LLC doesn't go away. It survives the death of its member, and the original seller, it doesn't change anything with the original seller. The original seller doesn't receive any additional rights with respect to the property. The existing lender doesn't receive any additional rights. It's simply a death of a member of an LLC, but the LLC continues to own it and continues to be able to act as the owner of the property as long as they fulfill their requirements to the seller under the original agreement. The next scenario is that you have an end buyer. So you have a buyer that ends up buying it in their personal name subject to the existing loans. So this would likely be a situation where the seller sells it to an investor subject to existing loans, and then the investor sells it to the end buyer subject to the existing loans and has some carryback financing as to that buyer. Well, let's say that that individual buyer passes away. Once again, the original seller, the investor who sold it to the buyer, doesn't receive any additional rights as long as that buyer's estate basically continues to perform under the original agreement with that investor, meaning they're paying the existing loans. They're paying the portion of the loan that's owed to the investor. They're basically performing under their agreement with the investor that sold it to them. None of that changes. Instead, the property becomes an asset of the deceased buyer's estate, and the deceased buyer's personal representative, or some states call it an executor, will be responsible for handling the affairs of the property, making sure payments are properly made under the loan with the investor seller. And then at some point, the estate will be administered, and the interest held by the buyer or deceased buyer will be conveyed to that buyer's heirs. and that buyer's heirs will then own the property, and they too must continue to satisfy the loans against the property and making sure that they're making the required loan payments. Another option is the deceased buyer's personal representative can decide, well, we don't want to keep the loans in place, and it makes more sense to sell the property. And so maybe they go and they sell the property to a third party, in which event all of the existing loans, the investors carryback financing will be paid off. It basically everything's paid off, and then the property sold to a third party. So that is what happens if a buyer passes away after the close of escrow on a subject to transaction.
All right. Thank you for the legal update, Sean. A reminder to all the viewers, July 5th, we are relaunching the Creative Finance Collective. And in short, we call it the Collective. If you'd like to kind of see a sample of the Collective and kind of what it looks like, we shot a preview, really, episode of the Collective in May. And with us, we had rap attorney in Texas, Alan Seschker, who spent some time sitting with Sean and I talking about creative finance. But that is the idea behind the Collective. It's a group of professionals, a group of attorneys who have their hands dirty in all respects with regard to creative finance in a variety of different states. And it's an opportunity for us to sit down and talk through what we're seeing in creative finance, how we can make each other better in creative finance, and most importantly to you, the viewer and the listener, it's an opportunity for you to ask questions the entire time. I really thought the first episode went really well. I enjoyed the experience. We've invited a number of attorneys to be a part of the Collective. So who you might see in a given week may be a lot of folks, multiple, in fact. But I really thought it went well. What did you think about it? And what do you think, Sean, our listeners can expect in the future from it?
Well, for me, my biggest takeaway was after having spent an hour just discussing the legal aspects of wrap transactions or subject to transactions with Alan, the next day, true story, the next day I sat down with my form documents and made changes because the discussion was so high level that it was like he pointed out a few things that made a lot of sense to me as far as his documents go and what he does. I'm like, oh, I need to add that, or I need to change that in my contracts. And he was saying, and I don't know if he did it, but he was saying, oh yeah, I need to do the same thing afterwards. So literally you have attorneys with significant experience in creative finance, significant experience in subject to and wrap transactions, who after speaking with each other for an hour are going and now updating and revising their documents because they've learned something through the process. So imagine if you're a listener being able to sit in and listen to these attorneys talk to each other in that way, in that high level of a manner. And basically you're like a fly on the wall, just being able to listen and take in what's going on in the room. And you're definitely going to learn something because, if I'm learning something, if Alan's learning something, our listeners, the non-attorney investors should be learning a whole heck of a lot during that. And that's really their opportunity to sit there and take in and listen to attorneys, go through and talk about this. So it's not like, hey, we're doing an education and we're going to do a presentation and, sell our services or anything like that. Granted, hey, if you're listening and you learn about us through the Collective, we're happy to represent you. But, the whole thing with the Collective is just putting attorneys in the room together to discuss high-level legal issues regarding creative finance. And the listeners have the opportunity to basically sit in and watch that discussion unfold and take place.
Well, what I thought was fascinating in talking with Alan just before the show had even started, talking about nuanced kind of ways of approaching creative finance that he was talking with people about. We were getting those same questions from other listeners. He's like, man, I was just talking with other folks about this same thing, so it really is kind of a real-time opportunity vet through and sift through some of these uncharted territory to some extent sometimes, or to really get the perspective from a professional in the industry. So you're right. It's a real opportunity. Again, we're going to be bringing it back and starting July, and it's going to be weekly, everybody. So every Wednesday evening at 5 o'clock Arizona time. The first one will be July 5th, 5 o'clock Wednesday evening. You don't have to join right when it starts, but you're going to miss out. So join in. We're taking questions the entire time. Really excited about the opportunity and know that you're going to enjoy it. With that, let's get into our topic today. So we're talking about dealing with difficult closings. Now, Sean and I, we both talked about this on a number of occasions. I think we enjoy these shows because we don't come from a state that requires attorneys to close typical deals. We're just not typically a part of it, especially residential home purchases. So having a closing attorney is somewhat foreign to us, but it's not a foreign concept in many of the states throughout the United States. It's pretty common. So to talk with us here and to discuss dealing with difficult closings, we brought on an attorney, Drew Jenkins, from Georgia and Alabama, to talk with us about it. Drew, thanks so much for joining us. We really appreciate it.
Hi, thank you, gentlemen, for having me on. I tend to agree with you all. I don't really, as far as, run-of-the-mill residential closings, I don't think we're actually necessary. I don't think it does much good for, the parties other than to raise the cost. But I do understand, like in Georgia, it is a requirement, and, we've got to follow what the law says for as long as it says it until we get it changed.
Yeah, I grew up in Arizona, and I had already owned a home before I went to law school. And I went to law school in the state of Virginia, and I arrived there and bought a home. And they said, you need to hire a lawyer. And to me, I thought, a lawyer? First of all, I'm what, in my early 20s? I should not at this age be having to hire an attorney yet. But I'm thinking the extra cost of this transaction. Now, at the time, I appreciated it and understood their role at the time. But it was such a foreign idea to me, coming from the West Coast, where it's always been, or for a long time been, all title companies. But Drew, tell us about Jenkins Title LLC, and tell us about your law firm as well, your practice, how you got into what you're doing, and tell us about all of what you do.
Well, yeah, so it's called Jenkins Title. It is a law firm, and it was actually done as a marketing purpose, right? No one ever calls me to ask about, hey, DUIs or divorces or anything like that, right? So I only get calls about real estate, and occasionally someone will want to know about car titles. Don't have anything to do with that, but I guess title's in the name. The problem is, though, is as we've grown, as we've been doing well and looking after our clients, it sort of now is acting like a handicap for us. So, when we're negotiating leases on behalf of commercial tenants or commercial landlords, people ask, well, who's Jenkins Title? Who's the lawyer? So we're actually in the process of expanding and creating what's called Maple Bridge Law. And that way, we're no longer going to get these strange looks. Like I was telling you all right before the show, we currently have a deal in South Carolina where I come in as lender's counsel. And the very first thing that the lawyer said is, why is there another title company in this transaction? And it's like, I'm lender's counsel. Nice to meet you too, right? Kind of one of those things. So, we're in the process of expanding, and it's great. Real estate is where I got my start. We are fortunate enough to have sort of an international practice as well. We have both a Chinese licensed attorney, and we have a Chinese speaking American licensed attorney, and we also have a Korean title agent on staff with us as well. So we speak multiple languages, and we deal a lot with international buyers and sellers. So it's kind of a really specialty practice area. You're talking about where we got started. So I'm from Birmingham, Alabama. And I got started dealing with the We Buy Ugly Houses franchisees. I don't know. Do y'all have any like the We Buy Ugly Houses people out there in Arizona?
That sounds familiar. Sean, do we have that
Yeah.
here? I think so.
Yeah, we do.
Yes,
I got my
pretty
start
prominent
with out here.
Yeah, I got my start with some of those guys in Birmingham, and we used to joke. So Alabama's a weird state. You talk about attorney states and title states. In Alabama, generally the closing attorney closes, but there's a separate title company that writes title. And so the title company that I generally worked with, we had a joke. We would say that, it's not just ugly houses, it's also ugly titles. Because you could imagine those homes got some serious issues that we would have to work through. And I've just really enjoyed it. I enjoy helping people kind of start and grow their businesses. Like you're talking about with the creative financing, seeing these guys when they go from, having an idea to all of a sudden, they have office spaces and a staff of 20 plus people. I mean, it's a wonderful feeling to see people be successful and to kind of help coach people along and be like, yeah, you can do business that way. And I got rid of a few clients last year because there's a lot of ways to make money in real estate. Just not necessarily the
Mm.
ways that I want to be associated with, right? So, helping people as they go through with that. But yeah, that's kind of what we do is real estate and more real estate, I guess.
So in addition to the title work, you guys are able to and do from kind of a traditional law firm practice, general real estate work, transactional real estate work.
Correct.
Do
Yeah.
you guys
So I
do any
mean,
you guys do any litigation at all?
no, no. That's what I tell people. If it forces me to leave my office, I don't do it. Right? Like, if you need to evict someone, great. Go call so and so. Hold it. First of all, what county are you in? All right, then go call so and so.
Right.
Oh, you need land use zoning? Not me. What county are you in? Oh yeah, go call so and so. Right? So no, I enjoy the paperwork side of it. I don't really quite have the constitution for the litigation side.
Now, you mentioned you came from Alabama. Do you have an offices, and are you officing in both Georgia and Alabama?
We do. We maintain like a Regus virtual office over there. Again, because of our background with being able to speak Chinese, we handle a fair number of the Chinese closings with UAB, the university there. So we're able to handle their closings. Unlike in Georgia, I can actually do the whole thing remotely. But we also have friends that we have in Alabama as well. So if we have like a commercial file, I can lean on one of my buddies and say, hey, can you pitch in on this?
Now, I know you have a presence on YouTube as well. Tell us about Bite Size Legal.
Yeah, so Bite Size Legal got started a few years ago. As I said, we've grown to the point where we're kind of outgrowing Jenkins title. So I haven't had time to focus on it, but I would just do like these really short, like 5 minute sort of topics or topicality on things that were real estate related or law related that I run into literally all the time, kind of like what you guys were talking about. You talk about all these different topics and how interesting it is. And so hopefully it was just a resource for either my clients or people who might become clients to look at that and go, oh, maybe I should not sign my LLC's name when I'm trying to sign a contract, which is something that we deal with fairly regular out here.
So a big topic, just I think in real estate, legal, and investment circles right now, for obvious reasons, probably the biggest of which is rising interest rates. But a popular topic for us here in the West, and in a lot of lawyers that we've talked to throughout the country, has been creative finance, creative financing, what are also called subject to transactions or wrap transactions, where the buyers are looking to buy property subject to the existing loans on the property. Do you guys handle title on creative finance transactions and or subject to transactions?
So we do, but like I've told other people, it depends on how creative you're getting. Now, I fortunately have never had a subject to go bad. But I have had other people's subject tos go bad that wind up calling my office to see if I can bail them out. And as I'm sure you're all aware, depending on exactly how it's put together, sometimes there is no solution, right? I mean, literally, like I said, I don't go to court. I've had to advise clients, you need to call a litigator and, drag the lender to court because, there's really nothing that we can do on our end. You're not the borrower, you're not on the paperwork. They don't want to talk to you and they just keep pointing to TRID guidelines. And well, I mean, you're kind of stuck. So no, I mean, we deal with a fair number of seller financing. Obviously, we deal with a fair number of assignments and double closings, right? But the subject twos, I'm a lot more particular about when I will actually handle that or when I just look at it and say, you know what, I'm really not the right attorney for this particular design.
So what kind of designs do you see that you're comfortable with? I mean,
So
what are
people
you
don't,
looking to see?
yeah. So people don't believe me, but I promise you I've got the emails to prove it. If your servicer or if your lender is like a small community bank, they will actually turn a blind eye if you sell it subject to, right? You just let them know, hey, I've got so and so, they're going to make repairs to the house and then
Hmm.
they're going to sell it. I'm just giving you fair warning because obviously every Fannie Mae and Freddie Mac security deed, deed of trust, mortgage, whatever your jurisdiction calls it, has a due on sale clause. right?
Right.
No ifs, ands, or
Mhm.
buts about it.
Yep.
So when they find out you've sold it, you run the risk of them just starting foreclosure and not talking to anyone. And again, I've had enough people come to me to try and weasel out of that situation to realize that's not a situation that you want to be in if you can help it, or you can if you just fully understand the risk. So number one,
Right.
if it's a small lender or servicer, if you can get tacit approval, no problem, right? So long as the parties agree, almost anything is possible. The second way that I'm kind of comfortable doing it is either the property goes into an LLC or a trust, and then obviously you set that person up as the trustee or the contact, right? And then that way you've created a little bit of an air gap between the actual owners and basically the payment of the loan. And so I think those two ways sort of offer some protections in a way. I mean, obviously the tacit approval is the best, that you don't get when your client purchases the property subject to the original seller doesn't like what you're doing to her mother's home, who happens to be across the street from her. She doesn't like the changes you're making. So she calls the bank and says, Mama died and I sold her property. And then all of a sudden, your client is calling you. Obviously, I didn't close that one, but he called me and was like, Drew, what do we do? And I'm like, not much. Will the lender talk to you?
So what are the big key differences just for somebody who's really watching the show and kind of learning from the beginning? Maybe they're learning what subject to or seller financing is for the first time. They're learning that maybe this is a possibility. What are some of the big differences for you as a closing attorney between I guess what we'd call a conventional transaction and the seller finance transaction or the subject to?
From the seller financing side, generally our firm is also drafting the loan documents for the transaction as well. And I mean, obviously, we have forms for that purpose, and it's just, and of course, we send the parties the, hey, what do you want the terms to be, right? How long? What's the default, right? What's the default rate? What are the rights between the parties? So a seller financing deal has significantly more paperwork that we have to actually draft, because there is going to be a loan, there's going to be a mortgage, again, mortgage, security deed, deed of trust, whatever your jurisdiction likes. And then, insurance. This is a big thing that I harp on with my clients. No one ever thinks about insurance, right? Unless they're a real lender. I mean, sure, you've got a mortgage. Congratulations. The house burned down. Now, what are you going to do? Nothing, right? So I really make sure, at least from my side, I make sure that the deal is actually buttoned up, almost kind of like a lender's counsel-esque, right? Because I do act as lender's counsel. I know kind of what you need to do to make sure that everyone is on the same page to get the deal done. As far as subject twos go, it really is just educating the client to make sure that they actually understand the risk profile. And again, if you're okay with that risk, like if you really understand what can happen, and you're like, yes, I understand, but you know what, let's pursue it, then there's really not much different from our perspective. It's just we're not ordering a payoff. And the thing that they have to know is their title policy is not going to ensure that. Like I told you, I have people that call me after the fact and go, oh, hey, I've got this issue, I'm going to make a title claim. And I'm like, good luck. It's right here in Schedule B, right? Subject to that security deed from to, as a previous owner, your policy does not ensure that. So, I mean, subject twos are not much more paperwork. The only ways that you're going to have a little extra is you're going to have an agreement, obviously, that the buyer acknowledges that they're taking the property subject to, that protects you as the closing attorney in a closing attorney state. And you're also going to make sure that the authorization is signed. You can do a POA, you can do an authorization. What matters is that the buyer is going to be able to have direct contact and direct access to the lender. That way they're able to make payments. That way they're able to order payoffs. That way, they're able to interact with the lender, and the lender's not going to ignore them. The downside is when the previous seller, again, gets their nose out of joint, calls the bank, tells them what they did, and they revoke the authorization, right? Or they revoke the POA. And then once again, you probably need to go hire a litigator and drag the bank to court real quick to get a payoff, because you are the titled owner, right? There's no problem with that. The problem is apparently the lending laws don't permit, at least according to the big national lenders. Again, small banks, small servicers, they just want to get, they're a lot easier to deal with. But the big national guys, they got their checklist. Checklist doesn't permit this. See you in court, right? That's kind of how they operate.
So a couple of questions about Georgia. So, in Georgia, are you guys a deficiency state? Meaning if
Yes.
somebody because we're anti-deficiency. So if somebody purchases property using, financing, whether, through a traditional lender or hard money or seller carry, if the funds were used or the loan was used for the purchase of the property, there is no deficiency rights. So there's no ability of the lender to pursue the borrower's other assets to recover the loan balance. Their only remedy is the property. So in Georgia, you guys don't have that. Meaning if the loan's 400, the property's worth 300, they can sue the borrower for 100,000.
Correct. And so there was actually a lot of discussion about this, and there was a slight change in some of the loan documents. It's probably about a decade-ish or ago, maybe 2014 or so. There were discussions among our commercial clients about making sure that they had these deficiency rights. And again, they altered the language of their commercial loan documents a bit to ensure that they were still able, because as a lot of the closing attorneys at the time said is, well, this property is being sold to satisfy the debt, right? And of course, you paid whatever you thought you credit bid, obviously. And so the thought was that you needed to credit bid the full value of your loan. And then once you did that, you were satisfied in full out of the property. The fact that you could not then make whole on the sale of your REO was not, was no issue.
Right.
You bid and you got property for what you bid for, therefore no deficiency. That was the argument. And of course, the lenders were like, no, this is not going to work for us. And again, at least on the commercial side, they tweaked their docs a little bit to ensure that they still maintain their deficiency rights.
So what kind of deterrent would that be? Because you mentioned, hey, there's a risk that, the seller sells the property, subject to they then have remorse for one reason or the other. The example you gave was, a beneficiary or personal representative.
It was the executrix of the estate, lived across the street,
right,
got mad.
Yeah, they could care less, right? It's not their credit on the
Yeah.
line, and it's not their, judgment judgment's not going to come down against them. But what about the situation where you just have Joe Seller who, sells the property subject to, but if they go and report it to the lender, all of a sudden they expose themselves to a deficiency judgment, and their credit is going to be, harmed, because a foreclosure is the worst thing you can do to your credit. And so if the lender accelerates and forecloses because of the due on sale clause, all of a sudden you have it there. Does that, create any like preventative, situations where you think, the seller may not be willing to do that in that case?
I think if the seller is aware that, so first of all, I have to point out, all the subject to transactions I've done, none of them have ever actually failed or gone sideways, right? So you have to know your seller. But if you're dealing with what I call a screwball seller,
Right.
I don't really think there's going to be much of a way to stop them from doing screwball things.
Right.
And so, you could definitely put that in the paperwork just to kind of warn them that, hey, you think that you're screwing over your buyer, but in reality, you're just kind of screwing yourself as well. But the people that are going to engage in this sort of activity are not the kind of people that are going to be too concerned about that to begin with. I had another file where the seller demanded an additional $60,000 or 50 or 60, I forget which, just because. After the fact, still carrying the mortgage, our flipper was still making payments on it. Seller just needed more money. And if they didn't get the money, they were going to call the bank.
Interesting.
So, as you mentioned, with difficult closings, there are all kinds of people in this world. And the most difficult, of course, are if you've ever run across sovereign citizens. I don't know if you've had the pleasure of dealing with them before.
Yeah. We do some of that work out here where we clear title. And we had somebody that was running around recording just junk against hundreds and hundreds of properties here in Maricopa and Pinell County. And our clients were going to close and like, I don't even know who this person is. And they've recorded this lien against my property saying that they're a sovereign citizen and they're entitled to ownership of this property. Now, Good news is somebody at the Attorney General's office got wind of it, and it is a crime to falsely
Cloud
record,
title.
cloud title. And so, they kind of, you know, axed it and, pursued criminal charges against them. But while those criminal charges were being pursued, we had to clear title, and it was horrible. We had to file special actions, lawsuits, and it costs our clients thousands of dollars. And of course, the sovereign citizen didn't show up, and it was cleared. But as you know, anytime you have to file a lawsuit, it's going to cost.
It's expensive.
It's not cheap. And we're doing it on an expedited basis to try to get the closing done, and it's really unfortunate. And what are you going to? Yeah, we get attorney's fees, but what, you're going to pursue the sovereign citizen for
You're not
attorney's
going to
fees?
get
You're not going to get anything.
squeezing blood from a turnip. And that's what I was saying is you can build in all kinds of deterrents. But at the end of the day, the kind of people that are going to cause trouble on a subject too, I'm not sure that those deterrents are going to be terribly sufficient, right? Because they always have some kind of reason for doing what they're doing. And
Mm,
generally, ruining their credit is not something that these people are terribly concerned about.
right.
That's why I said all the subject twos I ever dealt with, they went off fine. But
Mhm.
it's the ones that went sideways. I just had no real recourse for solving it other than, hiring a litigation firm like you guys or someone that would go to court, to try and force the lender to the table.
Let's talk about a couple other items, and this could be with regard to subject to transactions or conventional transactions that provide challenges to closing or getting the closing done. I think a common one or one that comes to mind in subject to transactions is oftentimes investors are looking for the best deal. So that what that might mean is a property that things aren't going well with the property. That could mean the property's not in great shape, or that might mean that the loans that are currently in place aren't in great shape, meaning they're delinquent. And maybe there's a pending foreclosure on the way. So things have to happen quick, or things have to be brought current quick. What kind of challenge does that present for you in Georgia in trying to close a transaction? How much time do you really need to be able to get that done when the clock might be ticking with regard to like a foreclosure and getting this thing closed?
Oh, you mean like the file that was supposed to be at foreclosure next Tuesday and we got the file opened last Wednesday? You talking about one of those kind of files? Yeah.
Yeah.
I'm very familiar with them. Fortunately, when a file is already in foreclosure, the lender is generally pretty quick to turn you to the law firm that's handling the foreclosure. So, at least in our area, typically once the foreclosure process has begun, the payoff is no longer in the hands of the lender. It's now in the hands of the foreclosing law firm. So the first thing they do is they say, go contact so and so for a payoff. And then obviously it's way more than what the borrower thinks they owe, right? And so as you said, you can do reinstatements instead, right? So obviously the loan's been accelerated, they want it all paid off, or they're going to foreclose, depending on the circumstances. One thing that is actually fairly effective for us is if you go ahead and you give them a signed, like legitimate purchase and sale agreement, sales contract. I don't know what y'all call it out there.
Yep.
We have been pretty successful at having foreclosure stopped or delayed, right? Restart the process to give you time to close because it's a legitimate buyer. We just need time to get title cleared, right? So can you give us time? And I'm not going to say more often than not, but it's certainly worth it to reach out and ask if they're willing to delay. Another way is to say, hey, can we do a reinstatement, right? What's the reinstatement price? And then that actually becomes part of the creative financing because I have had buyers actually pony up the reinstatement fee, right? As sort of like a
Mhm.
larger down
Right.
payment just to give them more time to push things out. Now, I don't know how long foreclosure takes in y'all's jurisdiction, right? But I mean, here, normally you start sending the letters when you're about 3 months behind, right? They might, send the notice of
Mhm.
acceleration. You got another 30 days. So, I mean, in reality, you're looking at from the time that you start getting in trouble with your lender to the time that the foreclosure occurs, you're generally looking at probably around 6 months in total, right? So, I mean, obviously, if you are trying to flip the property and you think you have like a 3 month fix and flip window, I have clients that are just willing to get in there, get it done, and then, just pay whatever it is before the foreclosure actually happens. So I have people that are pretty aggressive on that front as well.
So on that type of transaction, is your investor client who's doing the fix and flip, are they actually taking title to the property, or
Most of
how
the
are they
time,
in
not.
there? Oh, okay.
Yeah, for most of the time, not. So and I get onto them about it because I don't do too much like actual construction law work, but they get in there under some sort of an agreement and then they start, fixing the property up because again, they don't really want to close on the subject to side, but
Hmm.
they want to start making repairs and improvements, but they also want to preserve their rights. So they might file like a materialman's, notice, right? So in Georgia, you don't necessarily have to file the lien, but you can at least file the notice of commencement that lets everyone know, hey, the owner has allowed me on the property, and these are the improvements I'm making, at the request or, with the blessing of the owner. And so that way they're able to sort of protect themselves to an extent. Some of them, have closed subject to, right? They just kind of grab underneath it and then just kind of play that clock out until they can get to closing. Another one that I recently had a file, and it was another one of these super fast ones, but it was a local hard money lender. And I'm like, guys, just buy the note, right? Just call the lender and buy the loan. That way, whenever the estate, and obviously the estate adds a whole nother wrinkle. So we had a deceased owner and we had a foreclosure and we didn't have our letters testamentary yet, right? So we didn't have anyone who could sign on behalf of the estate and actually sell the property. So I said, hey guys, just buy the note, become the lender, and then you can restart the foreclosure later. You guys are still protected because you haven't paid off the loan. You've
Right.
bought the loan. So you now are the lender. So you're going to get this property one way or another. Either you're going to close on it at your agreed upon PSA price, or if, the estate tries to back out or do anything crazy, you are the lender. You can just foreclose just like we're dealing with now. And I mean, that's always another creative avenue as well.
And the lender in that case sold the note?
The lender did not sell the note. They actually
Oh,
looked at the circumstances because there's an estate involved and they actually stopped the foreclosure to give us time.
oh, okay. Well, that's good. Yeah, that was brilliant though, because if you think about it, if you have the resources to do it, you buy the note. Well, when you close, you're paying yourself back, right? I mean, ultimately. So that's, yeah. And maybe you could even get it at a discount. Who knows,
Yeah, well, I mean, the note wasn't that
So,
large, right? I mean,
right,
the person was deceased. The note had been paid down pretty far.
right.
I mean, you were talking like not even $90,000.
Oh, wow. Yeah.
So,
What about HOA dues, or a better way to say it, delinquent HOA dues? Is that something that presents a problem to closing a transaction in Georgia?
not generally. Georgia is not a super priority state. We're not like Florida, right? So they can't prime your first position mortgage or mortgages or anything like that. Obviously, we request the HOA letters. I mean, I hate HomeWise docs, right? Because they cost a fortune. Every year, it seems you're paying like $100 more for these letters. We get the letters, and then we let the seller know you owe HOA dues. Sometimes your seller is absolutely adamant that they don't owe anything. And so what we generally do here is we get a payoff that's pretty far in the future for them. And we say, look, we're going to give you until this payoff date to fight it, right? Like, the HOA claims you owe, I think one of them was $18,000, and you swear that there's no HOA. That's totally fine. We're going to collect the full amount to pay them off. Their payoff, this was last year. Their payoff was good through the end of July. We were closing in like May because, again, we knew that there was going to be an issue. And we said, look, we're going to hold these funds until the payoff is due. And if you can work out a deal, if you can negotiate it, great. And they asked me, hey, Drew, can you negotiate for me? And I say, no, I don't want to get involved, right? I try to stay, as a closing attorney state, I try and stay neutral, right?
Right.
I want to deal with everyone again. And so I say, no, you can hire an attorney or, you can negotiate with them. Almost always they fail, right? Because the HOA doesn't have to budge and they know they don't. I also have buyers who will buy it subject to the lien, and
Mm,
then they are generally more successful at negotiating it down, right? So again, a lot of these come up in estate situations, right? Mom or dad passed away, HOA dues lapsed for a period of time, the house wasn't taken care of, weeds, the whole nine yards, not just dues, but also violations. And I've had buyers like, look, we're going to close. We're already in touch with the HOA. We're going to get the door painted. We're going to get, I think one of them was, we're going to get the stairs and the railings repaired, and we're going to redo the driveway. And, we're totally okay with that. And so we close, subject to the violations, but they're not worried about it because they know as the flipper that they're going to get it all fixed anyway.
So in Arizona, HOAs are pretty prominent, and they don't have priority over first position deeds of trust, but they do over pretty much everything else other than property taxes, obviously super priority, but they have, priority over second position deeds of trust, mechanics liens, judgments, those types of things. And back in the short sale days, I did a decent amount of foreclosure and short sale work on behalf of, sellers and brokers and things like that. And our HOAs are generally, I shouldn't say generally, there are times where our HOAs are mismanaged, and you have these management companies who, so to manage a homeowners association in Arizona requires no license. So literally somebody could go down to the Corporation Commission, form an LLC called, HOA Manager LLC, and be like, hey, I'm the best manager in the world, and know nothing about HOA management, and end up managing all of these HOAs and giving them advice on how to handle their affairs and stuff. So I'm curious to see if you've seen this in Georgia, or you have these, horrible HOAs there. But back in the short sale days, it was not an uncommon occurrence for the HOA to submit a payoff to the title company that contained upwards of 5 figures of inappropriate charges, like tens of thousands of dollars. And then of course the broker or the seller contacts me and like, hey, can you audit this? So I audit. I'm like, yeah, they can't charge you for this and that and this and that. And it's like, literally, I think the highest one I had was 15 grand, where I'm like, you can't charge this. Like this is, and because in Arizona, you have assessments. So your regular assessments, which are liens, and then you have your fines, the failing to bring your trash can in before 5 o'clock, and the weeds and things like that, where they fine people. Assessments are liens, fines are not liens. They never attach to the property, but they'll throw in, tens of thousands of dollars in fines, or they will try to put money on there that's, or amounts that where the statute of limitations is expired, those types of things. And it's a lot. Have you seen that in Georgia, where these HOAs are just so horrible and difficult to deal with, like we have them here in Arizona?
I am very glad to report that we don't have that problem.
Oh, that's good.
Most of the HOA management companies are law firms that specialize in HOA management and HOA representation. My own HOA that I live in, we're managed by a law firm. My office building here, my little office condo I own, our HOA management company, she's also an attorney. So a lot of the HOAs, they either have professional property managers who themselves tend to be attorneys, or if they are self-managed, they tend to be even nicer because they don't charge for the letters, right? They might be a little slower to respond to you, but I mean, in my experience in Georgia, most of them are very nice. And if someone does actually owe a deficient or a late fee or a violation, it's generally pretty well documented that, yeah, you owe it.
Yeah. Well, yeah, be thankful, because they are crazy out here. I mean, crazy. It's insane, some of the stuff, the shenanigans these HOAs are, try to pull out here.
Right. One thing that we have here, though, is, I don't know if you'll have it there, but our sellers are a little less than honest sometimes about whether or not there's an HOA, especially when you're dealing with an investment property. And they will swear up and down that there's no HOA. They've never been contacted by an HOA. They have no idea what you're talking about. And of course, we have our DCRs, our CCRs, restrictive covenants, whatever you want to call them. So we know they exist. And then, we go to the Secretary of State's website and we see that no, this entity has been filing, their annual reports since the 1970s. And oh, look at that. Your president and treasurer and secretary all live on roads adjacent to your property. We're pretty sure they exist. Again, that's how that one lady had an $18,000 bill on her townhome. She swore there was no HOA. And I'm like,
Oh
you
my
bought a
gosh.
townhome, right? Like, those
Yeah,
things
right.
generally have HOAs baked into them, right? I hope
You're
for
sharing a
her.
wall with somebody. There's going to be an HOA.
Well, not always. There are
Hmm.
actually some,
Oh.
both here in Georgia and in Alabama, where the common wall is the responsibility of the common owners, but no one else, and you're also responsible for your own roof. So there are some
Interesting.
townhome communities that have no and never have had an HOA.
So when working with investors, sometimes it's not just the loans that are in bad shape or liens, but it could be the property itself. So in dealing with a bad property that maybe needs a lot of work, a lot of TLC in Georgia and Alabama, can you close a transaction where there are existing recorded code violations because I haven't kept up the property or whatever, it doesn't meet code?
Well, we certainly can close. I even closed on a brand new build that didn't have a CO, didn't have a certificate of occupancy. We were running into a 1031 exchange window, right?
Mm,
Obviously, it was for
yeah.
investment. She had to close, but the builder didn't have his CO yet because he was dealing with a variance hearing. Apparently, he was too many inches outside of where the building was supposed to be. We were still able to close. We just, like you said, subject to, right? Just pointing out here that there's an issue, and it's going to be your responsibility, Mr. Buyer, to settle it up if we're not settling it up at closing. So yeah, I mean, if you have a municipal violation, you just let them know and you close subject to it. I mean, so long as they're okay with it, and generally they are, right? Because I'll give you a great example. There is a city here called Macon, Georgia. It's
Mm,
in Bibb County. They have a unified government. And they're actually really, really, really smart with one of the big firms here. So rather than condemn the property and take it over and then you have to deal with it, they have created this new taxing regime where you are now considered a blighted property. And so your tax bill is now going to be 7 times what it normally would be as sort of a blight reinvestment fee so that the county can then use the funds to, help repair and remediate the blight. But if you get the property fixed and have our code inspector come out and look at it prior to the bill being issued later this year, then you know what? We're going to give you a credit and we're going to let your taxes be half of what they would normally be.
hmm.
I mean, it's a new thing that they're doing. It's really neat. It's technically not a lien. I spoke to the county attorney, right? And he said, yeah, it's a new thing we're doing. We're not actually liening the properties. We just want to make it clear. We file it of record just to let everyone know what the taxes will be, but it's not a lien and we're not claiming a lien. But you just need to let them know. And so obviously it's flippers that buy these homes and they're like, yeah, I'll get it fixed. And so then of course our problem is the closing attorney. How do we prorate the taxes? The taxes are either going to be 7 times higher than what they were last year, or they're going to be 1/2 of what they were last year. We have no idea, and it all depends on how quickly the buyer gets their repairs completed. So that's kind of an interesting thing to your point about can you close with these sorts of issues? And the answer is yes. And Macon has created a really interesting wrinkle on that.
Can
Can
the
y'all
bot
close out in Arizona? Arizona, can y'all close on those?
Well, once again, you can close subject to the code violations, but most title companies don't like to do that and are uncomfortable doing that. And so normally what happens is we go to the city and basically say, hey, look, we know this. My client is an investor. They're going to fix the property. And then they enter into some sort of agreement with the city, a written agreement, giving them a certain period of time to fix it. And then the city releases the code violation. And then if they don't fix it within, 3 months or 6 months or however long it's going to take, then the city will slap it back on the property again. So that's generally how we handle it.
That's pretty different. So a difference between Georgia and Alabama is in Georgia, right? The lien rights don't arise until they file the lien. right? So we don't have to go bugging every municipality of, are there any violations? In Alabama, we have to go bug every municipality, or are there any violations? Because the violation becomes a lien, just like with sewer, right? At the date that they generate the notice, not the date that they file it. So they have unfiled lien rights in Alabama as municipalities. Georgia, we don't have to do that. It's not a lien until they file it. So it's just another step that we have to do for Alabama closings. And in the same way, sewer in both states, depending on who your sewer provider is, they're the same way. There is an unfiled lien the moment that bill is generated, not the moment it's sent. The moment that they generate that bill in their system, there is an unfiled lien on the property, which means we always have to request sewer payoffs.
Yeah, that's completely different than Arizona. We never request sewer payoffs. I didn't even know that was a thing. Wow. Sewer payoffs. Interesting. And so how does your Georgia purchase contract deal with that? Who pays the sewer lien? Is it prorated or
No, it has to be paid at closing.
Okay.
So your seller has to pay for it, assuming that it actually is a lien, because Georgia takes it a step further and makes it even more complicated. It is only a lien to the extent that the bill was incurred by a titled owner of the property. So tenants and their water and sewer bills do not have the ability to lien the property, but only if they show up in title. So as you could imagine, that adds another back and forth sometimes. And I shouldn't say a lot, but some of the jurisdictions around here, they just don't even care. Right? Like, yes, statutorily, they have this unfiled lien right, but you know what? The cost of answering for every single purchase and sale, right? These letters about current status, it's just not worth it to them. So they say, we don't lien. Yes, they have the statutory right to do so, but the cost of maintaining that entire public facing system is not worth it to them. So they just say, we don't lien. And so over time, you learn which jurisdictions and which municipalities or which county sewer groups are aggressive and which ones don't care.
How long do they have statutorily to respond to a payoff request or a lien request?
Oh, you're talking about the government. So and a lot of times the ones that go
forever.
after it are the government, right? So you're dealing with like the county sewer or a city sewer system. They'll get back with you when they get back with you, and sometimes they're delayed. So I mean, I think one time we waited on one for almost a month, just because they were behind.
Yeah.
And I mean, what are you supposed? I mean, how are you going to speed them up?
Yeah. No. I'm with you on that.
So what challenges in a subject to transaction and getting those closed are presented when you're dealing with an FHA or a VA or the VA?
So with a VA loan, right, those are assumable, right? Assuming that you meet certain criteria regarding it. I don't think I've ever had any of my guys fool with a subject to from FHA or VA. And in fact, I have been very fortunate in that some of my subject twos were actually with hard money lenders. Right. And so obviously they don't care, right? Just keep paying them until the loan comes due. So I have been fortunate that that's not something that I've had to look into or I've had to deal with.
What about purchasing a property or a partial interest in property? So let's say a sibling group, 3 siblings inherit it. It still has a loan against it, right? One sibling generally steps up and pays the loan while they figure out what to do with the property. And then you generally have one sibling who isn't interested in paying the loan, but wants to live in the property for free because that's where they were living when the parent passed away, right? So they're basically squatting in the property and like, why do I want to sell, And the other siblings, one of them's paying the loan, like, well, I'm paying the loan. You're not paying rent, in that scenario, what does it look like to, and I've had investors do this, but from a title perspective or a closing perspective, what does it look like for an investor to buy, say, 2/3 of an interest in the property? So you buy out 2 of the 3 siblings.
2/3, that's a lot compared to what I've dealt with.
Oh, really?
So
you might only do 1 or 1/3 or 1/6 or whatever, but
way less than that. So I have a client who is a nonprofit that does some assemblages in like blighted areas and does like community redevelopment. And as you could imagine, those titles are I mean, it was owned by the great grandfather who died in the early 1960s. And now we're already down to like his great grandkids who were spread all across the United States. And so we identified about a 2% interest in the property through some of the heirs that lived in Illinois. And we could ensure that, right, as to the 2% interest in not all of the parcels, but enough of them for it to make sense for the client. And they acquire it, and then of course they begin their lawsuit, right? Either some sort of quiet title action or a division or whatever your jurisdiction calls it. Again, I don't go to court to do these things, but they have their attorneys to handle that side, but I handle the title side. And I mean, yeah, it's ugly when you're dealing with like great grandkids, right? You don't even know who they all are anymore, but you just keep running that tree down until you can identify someone. Then once you have like a titled interest in the property, then of course, just like with a partnership, right? The law can't force you to be in business with someone. The law can't force you to own property with someone. So you walk into court and you say, divvy us up. And oh, by the way, I've got cash to buy out the rest of them, right? We just need to agree on a price. So yeah, that's definitely something that I deal with. Again, to buy 2/3 would be an awful lot compared to what I'm generally seeing. But yeah, I mean, if investors want to go that route, that's certainly something that you do. And then you're right, you treat generally it's a brother. I don't know why. You treat him like the squatter he is, and you begin like eviction proceedings, right?
Very interesting. Well, Drew, thanks so much for being on the show with us. We really appreciate it. Tell our listeners how they can find you and connect with you.
Great. So as I said, we're just coming out with Maple Bridge Law to take advantage of the fact that Jenkins Title is still there, jenkinstitle.com, but also maplebridgelaw.com. You're still going to get us. It's just, hopefully going forward as we continue to deal with larger transactions, we don't keep getting these kind of weird looks about who's this title company, who's the lawyer, right? So kind of like, you guys with Fowler St. Clair over there that, we're not mistaken as just being like, I guess they are out west, just a pure title company, but we are a law firm. So you can come to our website. Again, like you said earlier, you can look at Bite Size Legal. I hope to put something back up there again soon, right? And yeah, looking forward to having people reach out if they have any questions. It'd be great.
Yeah, thanks so much. We appreciate you coming on and look forward to doing it with you again.
Thanks, Drew.
Thank you, gentlemen.
All right, with that, everybody, thanks for joining us. Make sure to join us next week. We'll see you then.
Have a good day, everyone.